All right, if everyone can please whisper. Court is calling 2025 CR 010818, State versus Julian James Montez Jr. Can I have parties announced?
Bob Braubach for Montez.
And are you Mr. Montez? Counsel, have you received all discovery? Did you review it with your client?
Yes, ma'am, I did.
Court will find that the state is in compliance with discovery. Mr. Montez, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, ma'am, we do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Silence falls instantly. In this charged courtroom, every whispered response tightens the air as Mr. Montez confirms each solemn step. Discovery reviewed, rights acknowledged, indictment accepted. Yet beneath his steady answers, a deeper uncertainty lingers.
Mr. Montez, did you review court's admonishments with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places? You're charged by indictment with possession of a controlled substance, penalty group 1 gram to 4 grams. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Listen to the weight of truth. As the charges unfold, each warning strikes heavier than the last. 10 years at stake, every right surrendered by choice. Yet even now, one unspoken hesitation shadows the plea.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to present you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, he's mentally competent.
I'm sorry, if I could have that trial court certification back. Thank you. Mr. Montez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Oh, Your Honor.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, sir.
Everything hangs on this moment. Deferred adjudication offers hope, yet one mistake brings 10 years crashing down. Competency affirmed, threats denied, representation trusted. Still, a single unanswered question rises quietly, waiting to challenge everything said.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry into the country. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 6 years in the prison. There's a $1,000 fine, and the state is silent on your application. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, ma'am.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Consequences reach far beyond this room. Deportation warnings, echo, rights waived, penalties fixed. A 6-year cap waits if the plea stands. Pages signed, appeals surrendered. But beneath the formality, a turning point edges dangerously closer.
Counsel, have there been any such motions?
No, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor, seat off receipts, exhibit 1 and all attached.
No objection, Your Honor.
Did you review the waiver and stipulations with your attorney? State you may be excused. Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses, the state would call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
The truth is sealed in paperwork. No contest spoken softly. Exhibits admitted without objection. Testimony replaced by cold reports. Rights acknowledged. Evidence locked in. Yet the final judgment drifts just beyond reach, sharpening the tension around him.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, if you want to request a PSI and TAP evaluation, it will take approximately 8 to 12 weeks because there's a backlog.
Yes.
And, or if you want, he can be brought back sooner, probably in about 2 weeks, and you can bring whatever evidence you want the court to consider.
We can come back in 2 weeks.
All right, and you're waiving PSI?
No, I think we want a PSI. I think
All right, so then that's 8 to 12 weeks.
we'll do the PSI.
All right, I need a date for PSI and TAP. All right, we'll see you back on January 8th. At that time, I'll make a decision on your application based upon whatever evidence is presented to the court. All right, thank
You,
you.
Judge.
Hope balances on a judge's decision. Guilt deferred, evidence reviewed, future postponed for weeks. January awaits with possibility and consequence intertwined. As this chapter pauses, remember every choice shapes destiny. Stay with the story and seek understanding beyond judgment.